All right, how's it going? This is Today in Art. Today is April 21st, 2020. And we have a article that came out probably about a week ago now. It's saying that the court rules photographer gave up exclusive licensing rights by posting on Instagram. So this seems to be a case that happened in the state of New York. It looks to be. There's a possibility it could be overturned at like a higher court. But essentially, as of now, they're saying that because this professional photographer publicly shared their photos on Instagram, that they gave up their licensing rights by agreeing to the terms and service of Instagram. So we'll actually get into the article here, and we'll kind of look at some other stuff as well. Mashable beats a lawsuit by convincing a New York judge that it legitimately used an image on social media. When it comes to appropriating images found online, the situation is understandably confusable. If an individual posts something on social media, does that give someone else the right to use it in a different form? Most lawyers would likely answer not so fast, and yet on Monday came a suggestive ruling, perhaps otherwise, from a New York federal court. The plaintiff in the case is Stephanie Sinclair, a professional photographer known for exploring gender and human rights issues around the world. Her work, and it links to her website here, so you can see some of her stuff here if you want to. It's just StephanieSinclair.com if you want to look into that. Her work has been featured in the New York Times, Time Magazine, and National Geographic. She uploaded one of her photographs, an image of a mother and a child in Guatemala, to Instagram. Later, the news site Mashable contacted her because it wanted to reuse the image for a story on female photographers. Mashable offered $50. Sinclair declined. Mashable used the image anyway by embedding her Instagram post in its story. Sinclair claimed copyright infringement. And this is the actual article here. I noticed when you go through, it's like listing these photographers and like kind of like they pulled like an Instagram post on some of them, and some of them it's just the image. But if you go down to Stephanie's down here, you'll notice that the photo is not there anymore. So I wonder if they took it out after the fact or what exactly happened. How would the case play out? Would it turn on application of the so-called server test, where liability for direct infringement depends on where the infringing images are stored? 2 years ago, in a case that involved an embedded image of NFL quarterback Tom Brady, a different New York federal judge rejected the server test and ruled that the news website could be liable for using embedded images. That ruling had throngs of lawyers expressing concern about a potential disruption to the online ecosphere. Oddly, the decision in Goldman v. Breitbart gets only a brief mention on Monday's opinion. Basically, a footnote to explain the embedding process. Instead, U.S. District Court Judge Kimba Wood decides to veer in a totally different direction, and in doing so, light potential fireworks. So those don't know a lot. I'm not a lawyer I'm not a lawyer at all. I don't know law. But from what I understand, basically, if something is done and like a new case comes in that kind of like sets something new, like a precedent has been set, it's hard to get that overthrown, and that can be used in other cases to be used as defense or whatever it could be, because other websites now can start taking people's images through Instagram, especially probably in the state of New York, and they can like reference back to this case here, saying they're like legally justifiable to do it. Here, Sinclair granted Instagram the right to sublicense the photograph, and Instagram validly exercised that right by granting Mashable a sublicense to display the photograph. Rules Wood. Wood comes to this conclusion by discussing how Sinclair agreed to Instagram's terms of use when creating her account. Those terms granted to Instagram a non-exclusive fully paid and royalty-free transferable sublicense, worldwide license to the content. But you'd assume that'd be to Instagram and not other areas or other companies. Wood writes that because Sinclair uploaded the photograph to Instagram and designated it as public, she agreed to allow Mashable and Instagram's business sublicense to embed the photograph in his website. If you go to our website here, you go down to the bottom, you hit that. She's actually now made it a private account now. So I'm wondering, but here's the big issue as well. Like, if you're already an established photographer, it may not be so bad, but like trying to be like an up and coming photographer, or like trying to network or gather attention or get clients, whatever, like Instagram is a huge area for photographers, and even like video and stuff too, doing short clips and like reels and stuff to get, like, social network as a whole has become a huge way to network and advertise and try to get potential clients. I mean, you can have your own website, which obviously she does and other people do, but a lot of stuff being shared is going to be through things like Facebook and Instagram and Twitter and other like social media websites. So I'm wondering how that's going to play, because I don't know how that's going to play unless people start making their stuff private, which potential clients then can't see it. I don't know. It just seems like it's a terrible road to go down. For years, there's at least been some theoretical concern in the creative community about what rights are forfeited by using social media to share expression. Almost a decade ago, Warner Brothers bought rights to a story that was posted on Reddit, leading THR, whatever that is, to examine whether the studio actually held exclusive movie rights. A few years later, Sony was primed to do battle over the creepypasta internet meme that had formed the basis for the horror film. The case settled. Now Wood comes out with an opinion that addresses Sinclair's argument, many of which have been bandied about by others in different contexts. The judge rejects the proposition that Mashable had to get a license directly from Sinclair, or that it's not within the court's purview to analyze the meaning of Instagram's agreements and policies. Further, the ruling shoots down the argument that Mashable had no license because it wasn't the intended beneficiary of Instagram's terms of use. The opinion read below runs through more legal arguments before getting to something that could spread chills in the creative community. Sinclair argues that it's unfair for Instagram to force a professional photographer like her to choose between remaining in private mode on one of the most popular public photo sharing platforms in the world, and granting Instagram a right to sub-license her photographs to users like Mashable, writes the judge. Unquestionably, Instagram's dominance of photography and video sharing social media, coupled with the expansive transfer of rights that Instagram demands from its users, means the plaintiff's dilemma is a real one. But by posting the photograph to her public Instagram account, plaintiff made the choice. This court cannot release her from the agreement she made. So, and granting Instagram had a right to sub-license her photograph to users like Mashable. Yeah, that just seems weird to me. James, Bartholomew? Attorney for Sinclair, expressed disappointment with the outcome. We believe no photographer knowingly contracted away their ownership rights in their photos when they choose to use Instagram. He added, We remind everyone that it is only one single federal district court opinion, and is not binding, and is not the binding law of the United States or even the Second Circuit Court of Appeals. Our client is considering an appeal. Then they have some of the court documents here if you want to go to it and look at it. Yeah, so it's like they were saying, it's a big concern, like, because if you want to be found as a photographer, like up and coming, yes, you should have your own website and everything, and that should be your main area. But like so much of networking and advertisement is done through social media itself, as well as Instagram being the biggest photo app in the world right now. It's kind of, I don't know, because I have a photo page like chrispack photo, and I have it public because if you want potential clients to possibly find you, you got to have it there. But I don't know. I just, because I'm curious if it's going to get upheld and what exactly is going to happen, because these things usually take years to go through. But as of right now, it seems to be it's in New York, and whether this is going to be used to, whether this is going to be upstanding for other possible cases with the photographers dealing with, you know, copyright infringement or like whatever it is. Because I did a previous one where it was like a previous video where like Aaron Carter used like an artist's artwork to like help promote his album or song or whatever, or merch or whatever was coming out. He just like snagged something off the internet and used it. Because when you're like, especially when you're dealing with like meme culture, a lot of it's just ripping it and resharing it, which technically someone could come after you about it, but most of the time they won't. But when it's used for something and that person is like profiting off your own intellectual property, that's when a lot of times the lawsuits will come in for like reparations, or if them using your image for whatever it is, like, is damaging your brand, so to speak, then you could sue for damages. So I'm curious what you think about this. I think it's a terrible precedent to set, and I don't know. It's just, it needs to be overturned. But it's kind of shitty of them. They're like, hey, we'll give you $50. I'm like, no. Then they just, oh, we're gonna do it anyway, and say because the sub-licensings of Instagram, we can do it. But like I said, now she's put it under private. But like I said, she has her own website and everything too. So you can't just, if you ripped straight off of there, then that's kind of a drying, what was it? That's like a, you can't do that, essentially what I'm saying. But I don't know, tell me what you think about this. I think it's terrible. If you want to support me in any way, I got a Patreon here if you want to check that out. If you don't, that's cool. Whatever. All right. If you like this, you can give me a like. If you really liked it, you can subscribe. All right. Peace.